Hey, Lee and Mike here with another In Brief. Today we're going to revisit the wonderful world of good guy guarantees, and we're going to look specifically at a recent complaint that was filed by a landlord against the city of New York, alleging that they call it the guarantee law, but the recent codification to the administrative code by the city of New York, which ostensibly suspends personal guarantees for commercial leases through the end of September, is unconstitutional. So we thought it might be a good time to actually just have a really quick refresher on what good guy guarantees are. So I thought Mike would start off with that, and then we could talk about the case.
Sure. And we're dressed in uniform for a reason, so it's just like, two halves of the same mind bringing our thoughts. I couldn't grow a beard fast enough, otherwise it would really be a little awkward.
Yeah.
Yeah. One of the issues with not reporting to an office is we don't know what we're wearing until we get on camera. So sorry, I don't want to get too off track. So when you sign a lease, and if a guarantor is required, this is a case where the landlord looks at the credit of the tenant, and if it's an entity, they may say, even with the security deposit, we still want some other party on the hook for all the obligations. So a full guarantee would be one or more parties. Could be a person, it could be another entity that guarantees all the obligations of the lease. And what we refer to as a good guy guarantee is also known as a limited guarantee, with the idea being, in its most basic form, if you surrender the space, your personal liability, if you're the guarantor of the lease, cuts off at the point where the keys are surrendered. Now, in New York City, there's often a notice requirement. Could be 60 days, could be 90 days. So even after you've returned the keys, if the notice period hasn't run yet, you personally are still on the hook for that period. But that's just another form of a limited or good guy guarantee. And the idea is that it cuts the personal liability off, leaving the landlord with just the tenant entity to sue for the damages for the default. So again, we're focused here on situations where the guarantor is a person, because the law that we're speaking of has suspended through the end of September. I think it's September 30th, inclusive of that day. It suspended the personal liability under guarantees of commercial leases in New York City.
Yeah, so we were expecting a constitutional challenge to this law when it was first signed. There may have been others, but we just became aware of one that was filed on July 10th in the Southern District, and it's Marcia, Melendez, etc. versus the City of New York. If you're looking it up online, it's case 120 CV 05301, and they're really making two arguments. The first argument, which I'm not going to spend too much time on, is that the laws of the state preempt the laws of the city, and they're at odds, and therefore the law can't be enforced because it's preempted already by laws of the state, which would make the guarantee enforceable. The second argument, which is the argument that we kind of were expecting, is that the law is unconstitutional because it violates the contract clause. And speaking to what you were talking about before, the argument is these deals, these commercial leases were made with small businesses, specifically because there were individuals, whether they were connected with the company or not, who had substantial assets that could guarantee the lease obligations, whereas these smaller businesses on their own would not be able to provide sufficient credit or sufficient guarantee that they'd be able to satisfy the obligations under the lease. So landlords entered into these contracts, entered into these leases in reliance on these guarantees, which the city council law, the administrative code, has effectively now made moot, because you can no longer enforce these guarantees. So they're arguing that the law is unconstitutional because it violates the contract clause, and I'm guessing this will be the first of many similar lawsuits. I want to have a conversation about how this should impact tenants when they're thinking about whether they want to surrender their lease, how they should go about doing that. There's obviously this case, there are more to follow, but landlords are going to be making these arguments in their lawsuits against guarantors. They're going to be arguing that the guarantees are enforceable. They might make an argument that the law is unconstitutional, or they might make an argument that the law doesn't apply to a specific guarantor. So, Mike, I know we're speaking to a lot of tenants. Many tenants are aware of this law. We talk to our clients and other tenants about this law. I think that some tenants feel as if it's a given that if they were in business during COVID, that this law is going to apply to them and protect them. What are some of the risks in thinking that way, particularly in light of a case like the one that was just filed on Friday?
Yeah, and actually, before I jump too much into that, just really briefly, you mentioned something important. This is not the only challenge that we may see to this set of laws. This is the constitutional challenge. There are some other ambiguities that we've talked about, in prior videos, where we may still see these get tried, and we may get decisions on these. The most important being there's a distinction between signing as a personal guarantor directly on the lease and having a separate guarantee instrument.
Right.
I've said, and I think Lee's agreed, and most of our colleagues we've spoken to agree, that the intention of the law is meant to cover a separate guarantee. It's often cross-referenced in the lease, and it's part of the consideration in the deal. So it's hard to argue if you're a landlord that because it's a separate instrument, instead of having it in the same document, that it shouldn't apply. But that could be coming. I think.
If anything, the argument made in this lawsuit is actually a good argument to underscore that.
Yeah.
We relied on these guarantees in order to sign these leases. You can't really make the two arguments at the same time.
Right. Yeah, I think we'll see one or the other. So either way, whether it's this one that prompted us to have this video discussion, or if it's some other line of attack that a landlord takes, the key is, you have to expect that the landlord is going to challenge it, and they're going to try to sue to enforce the guarantee. So even if we're very comfortable by the end of September that the law is going to be upheld, it doesn't mean that a landlord is not going to try to challenge it. And there are costs associated with defending a lawsuit. So I would say, to the extent that you have some reserves that you can plan to start putting aside, or that you already have, make sure you have enough reserves to be able to defend that against that line of attack. You may still have to appear in court or try to settle. It's not a given that you're simply going to be able to walk away, because a landlord can challenge it, and there are always fees associated with defending a lawsuit or a legal challenge. I think the other thing is, don't give up on discussions. A lot of our clients or people we've spoken to are looking to make deals with their landlords, in some cases to be able to walk away and limit their liability, and in some cases to restructure the lease for a longer period of time. It's a little bit easier in some ways for a tenant that knows that they need to walk away, they can't be viable in the space because they're just trying to limit their losses. For a tenant that would like to stay in the space and it's a closer call, this is a really difficult period that those tenants are still going through, because if you have another 2.5 months essentially on your runway before you either you take off or you miss it, you miss your opportunity to have protection under this law, it could be hair raising. Nobody knows if we're going to have a second wave. The city council may extend it. Maybe this constitutional challenge is upheld and they won't be able to extend it. So you have to almost plan for this to fail, this protection to fail. And of course, an attorney who you hire is going to do their best, to try to get you this protection. But I think it's better to be conservative and assume that this is not going to save you, and then hopefully it will if it comes to be necessary. But those are probably the most important points to keep in mind, is that none of this, very few things when it comes to, to the law, and especially things that have to be litigated still, are a certainty. This is not a certainty, and the landscape is changing each day, just like, the economic and health environments, for lack of a better word that I can think of on the spot, are changing every day. We have to be mindful of the challenges that are to come. I think those are my 2 points. So I don't know if you have anything you want to add to that.
Yeah, no, I just have one thing before we stop the pain of people looking at our two blue simultaneously, which is to piggyback off of a point you made about reserves and how you want to use your money effectively. Um, a lot of people we're talking to recognize that their corporate entity has no money left because of the pandemic. There's very little there for a landlord to come after, and most landlords are cognizant of that too. And so they say, okay, well, I have this law. My entity has no assets left. What do I have to worry about? And no matter what, if you're sued individually, you have to show up in court. You need to defend the lawsuit. If you don't show up, there's what's something called a default judgment against you, and you could be liable. If you're sued for the full liability under the lease, you could be looking at a 6 or 7 figure dollar default judgment, and it's very difficult to get out from under that. So you can't kind of think that way. You have to think, all right, let me think about whether I'm going to use my reserves now to give myself some peace of mind and try to negotiate kind of an amicable resolution to this. This is if you want to leave your space, of course. Or am I going to hold those reserves and am I going to put them somewhere? Am I going to allocate them to a potential legal defense? Because if my entity gets sued and it has liability, or if me or a family member who guaranteed the lease for me, if they get sued, there's going to need to be a legal defense. And the legal defense might ultimately be as or more expensive than it would cost to just get out of the lease now. So these are, we pulled this case and we're talking about this case to kind of illustrate that this law is not ironclad. There are holes in the drafting of it. I think the intention behind it was really good and right for the time, but it was drafted very quickly. And we've already seen landlords crafting ways to get around it. And now there's this constitutional challenge, and who knows how that's going to play out. So these are all kind of considerations that tenants have to think about when they're trying to figure out, do I want to surrender space and how am I going to go about that? And very valuable to not just think about what's going to happen over the course of the next month or two, but what's going to happen over the next few months or years as these laws are challenged in court, as the lawsuits begin to play out, as landlords and tenants see the landscape of how judges are deciding these actions. It needs to be a really careful business and legal decision when you're analyzing the enforceability of your guarantee.
Right. Yeah.
My pleasure. We'll talk again soon.
Be well, everyone.